Okay, so professors, we are still on the element of a contract. We've seen the offer and acceptance, the mutual consent. Um, oh, please remind me now. I forgot to know. Clarity of the terms. Yes. So we are picking on consideration, which is a very, very vital element in contract. So let's look at what it is. Consideration is something of value that can be exchanged by parties involved in a contract. So it should be of value. If it is valueless, it cannot cut for consideration. So it could be money, it could be goods, it could be promises, or it could be an act or a conduct. Okay. Now, it is normally paid by one party to secure the obligation of the other party in a contract. What does this mean? What it means is that if somebody provides consideration, that person has been able to secure an obligation on the other party to act or refrain from acting. In simple terms, if we are having a contract, okay, for example, I should give you 1,000 cedis, you give me your phone. Immediately I provide the 1,000 cedis, which becomes a consideration. I have secured an obligation. In other words, I have been able to do something that by hook or crook, you must also act in good faith towards me. So that's what is meant by securing the obligation of the other party. Okay. All valid and enforceable contracts must be supported by consideration. This implies that each party to the contract must provide something of value in return for the benefits received. Now, let me give another example. If you tell me to wait at the bus station to secure a bus for you, and in exchange, you are going to give me 500 Ghana cedis. If I go to the bus station and I stay there and able to get you a seat in the bus, what have I done? I have provided consideration. Now, this consideration you see is not money or goods, but it's an act. I have gone there, sat down. I have acted in a way that you have to, also satisfy your obligation towards me. That is giving me the 500 cedis. So that is just to clear that consideration is not always money or goods. It can be acts. Okay. Now, consideration can be classified as in types of consideration. And we are going to look at these types of consideration. There are cases supporting consideration, and let's read one of them here. Let me get one of the birthday boy. Please start the reading. Birthday boy Augustine Akoli. Please read this case for us. And
so please, case study. Glassbrook versus GCC, 1925. That's during a coal mining strike, the police were duty bound to protect the mine and proposed mobile units for protection. The mining owner requested stationary police on the premises and promised to pay for the extra service. The police complied, but the mining owner later refused to pay, arguing that the police were simply performing their public duty.
thank you very much, birthday boy. Thank you. Happy birthday once again. So this is a case where a mine owner was asking the police to, provide some protection, for the mine. But listen, the police initially proposed mobile units for protection. What does that mean? It means the police wanted to do as in they pass through, they come, they go, they come, go, mobile. So they were not going to stay there or be stationary there. Okay. Now, the mine owner gave a counter proposal that he wanted them to be stationary there. Okay. Now, the police complied with this request, but then the mine owner said he was not going to pay them. Okay. Because they were doing their normal duty. But we all know that the police, as part of their patrol, they don't stay at one place. They move up and down. So if you are asking them to stay, and indeed they stayed, what it means is that they have provided adequate consideration. They have acted in a way that has made the mine owner obligated to satisfy his side of the contract. So the court ruled that although the police were required to provide protection, yes, the police provide protection, okay, but they had a discretion in how to do it, either to be stationary or move. They decided to move, do the mobile protection. Now, since the police went beyond their normal duties by stationing officers on the premises, instead of using mobile units, the extra protection was considered good consideration. Therefore, the mine owner was obligated to pay for the additional police protection as promised. Okay, so this was a case where consideration as an element of contract was used to judge the case. Okay. The next one is Dunlop versus Selfridge. Let me get one of us to read for us. Prof. Caleb Kwam, can you read this for us? Prof. Caleb. Okay. Because of our time, let me see. Prof. Ethan.
Yes, sir.
Yes, please read this case for us.
So please, can you come again?
Please read the case for us between Dunlop and Selfridge.
Okay. The producer of tires agrees to supply to a retailer at a discounted price, provided the retailer did not resell the tires below a certain price. The retailer agreed and contract signed. Later, Selfridge did not act as he promised, and Dunlop sued him.
Okay, thank you very much. So look at it. The tire producer agrees to supply a retailer at a discounted price, provided the retailer did not resell the tires below a certain price. The retailer agreed and the contract signed. Later, Selfridge did not act as he promised. Selfridge is the retailer and Dunlop is the tire manufacturer or producer. Okay. Now, the manufacturer of the tires sued him that why have we agreed on something and then you are refusing to, act? The court ruled that the retailer promised not to sell below a certain price is a consideration. Okay. Therefore, the court ruled in favor of the manufacturer of the tires. So you see that sometimes consideration is not only, money or goods, something tangible, but a promise not to do something or to do something constitute consideration. Okay. Because in this contract, why was the manufacturer ready to supply the tires? Because the retailer agreed not to sell below a certain price. So what valuable is the retailer doing in this contract? That is, he will not sell the tires below a certain price. That's the consideration he provided. Okay, great. Now let's continue to look at the types of consideration. The first one is executed consideration. Executed. Who is reading this for me? Prof. I'm trying to get all of us to talk in class. My namesake, Irama. Let me hear your voice so that at least my morale can be boosted. Amwa. Prof. Irama, can you read executed consideration for us?
Yes, please.
Okay.
Executed consideration. This type of consideration is where one or both parties to the contract have already performed its part of. For instance, Jemima agreed to pay 40 cedis to Chaplain if she delivers a book titled Business Management to him. Jemima immediately delivers the book and Chaplain is yet to pay or fulfill his part of the contract. Into bracket to pay 40 cedis. The consideration into bracket the book delivery is executed.
Okay. Thank you very much, Prof. So executed, I think the word executed, what does it mean? Okay, something that has been, already performed, right? So if a party has already performed his or her part or its part of the contract at the time the contract is made, then that is considered an executed consideration. So if you look at the case that she read, Jemima agreed to pay Chaplain 40 Ghana cedis if she delivers a book to him, right? Now, Jemima immediately delivers the book and Chaplain is yet to pay or fulfill his part of the contract. Okay, so since Jemima has already delivered the book, that is considered as an executed consideration. So if you agree or you enter into a contract with somebody and the person has already fulfilled his part or her part, that is considered an executed consideration. And you have no excuse than to also perform your part of the contract. Okay, please, any question on this one? So even in the case where the police, okay, the police case, right? The police versus the minor owner, okay. You can tell that there was an executed consideration on the part of the police. The police had done their stationary protection. So it was only left with the mine owner to also, provide his consideration or part of the contract. Okay. Great. So let's move on. There is another case that talks about the executed consideration, and this is about Miss Carlisle versus Carbolic Smokeball. I think we are all familiar with this case, where the woman used a medical device or the medicinal device, okay, and then still contracted the disease, and the company was refusing to pay. Okay, now what was considered as executed consideration was the fact that Miss Carlisle bought the thing and used it as directed by the company. So she had provided a consideration, and that consideration was classified as being executed. She has already performed her part of the bargain or the contract. Okay. Please, any question? Please ask questions. So if not, when I give you exercises and assignment, then you get confused. Okay, let's look at the second one. The second one. Executory consideration. Let me read this one. It's a consideration that is to be provided at a future date. So you see the difference between executed and executory. So executed has already been performed. Executory is it will be performed at a future date. So for example, if Ajay promises to pay Ajewa 50 Ghana cedis next month if she agrees to deliver a book to him next week. Both Ajay's and Ajewa's promises are executory since the actions are to be performed in the future. So, for example, if I tell Augustine Akoli, if you get 8 A's in your WASI, I'll give you 1,000 Ghana cedis. You see, both considerations are what executory because Augustine is not writing the WASI now. He'll write it in the future. Okay, and therefore, the money I'll give him is also in the future, terms. So both the consideration that should be provided in this contract is executory. But if we agreed that, for example, Augustine, I'm giving you 1,000 Ghana cedis now, so that in your WASI you get 8 A's. Then you see that my consideration will be what? Executed, because then I would have given the money to Augustine. Okay, so that's the difference between executed and executory. One has already been performed, one will be performed in the future or at a future date. I think this is plain English and we all understand, even though we are looking at law. Okay, so there is a case there, right? The government of Western Australia offered a reward for information leading to the conviction of certain criminals. Clark provided the information, but admitted he had forgotten about the reward at the time he gave the information. The court held that Clark could not claim the reward because his information was not provided in exchange for the reward offer. He had no intention to accept the offer at the time he provided the information. This case highlights that both promises, the government's offer and Clark's information, must be executory and intended to be exchanged. Please, do you understand the case? Let's digest it again. The silence means that something is not correct here. The government of Western Australia offered a reward for information leading to the conviction of certain criminals. Now, Clark provided the information, but admitted he had forgotten about the reward at the time he gave the information. Okay. Now, the court held that Clark could not claim the reward because his information was not provided in exchange for the reward offer. He had no intention to accept the offer at the time he provided the information. This case highlights that both parties, the government's offer and Clark's information, must be executory and intended to be exchanged. Let me hear your thoughts. The way you are silent, let me hear your thoughts. I have 5 minutes. If not, then we'll look at it in details in the next session. Who is going to tell me something about this case? Yes, Prof. Na.
Sir, please, I wanted to say that I don't really understand the court's ruling.
Okay, you don't understand the court's ruling, So we have to dig deeper in this case. Okay, no problem. Is there any of us here who would want to attempt digesting this case? Yes. Augustine Akoli, let's hear you.
So please, I don't really agree with the court. Sir, because the government offered a reward for the information. That means that if you provide the information, they should give you they must give you the reward. Then someone called Clark provided the information, but he admitted that at that time, you had forgotten about the reward. But the government also said that anyone who provides the information would receive the reward. So maybe as what about the information? So you must come to Clark that, maybe you've given us the information. 2 years for a reward. That depend on clerk side.
Okay. Okay. Thank you very much. I think I'll dig deeper into the case. I'll give you the details of the case so that we can fully understand. Okay. But here the case was between the Republic of Western Australia and Clark. Okay. So it was the country suing Clark, not the other way around, not Clark suing the Republic. So let's meet in the second session and I'll give you details. You don't want to miss the details of the case. It's a very weird case. In fact, it was very chaotic, but I'll give you full details and then you can appreciate it. That's why you have Republic. The R is Republic versus Clark, right? So I told you that the first person is the plaintiff. Okay, the plaintiff is the one who takes the issue to court to sue. And the second party is the defendant, the one who has been sued and has to defend himself or herself. So it was the country or the government suing Clark. Okay. So let's meet in the second session. I'll give you the details of that case and then we'll appreciate this executory consideration and executed consideration. Thank you, profs.